बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, मैं हूं मलिक फ़याज़ अहमद वर्ड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरा यूट्यूब चैनल। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली मालूमात आप तक पहुँच सके। प्यारे व्यूवर्स, आज हम पढ़ेंगे सेक्शन 403। पर्सन्स वंस convicted or acquitted not to be tried for same offence. Number 1. A person who has once been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall, while such conviction or acquittal remains in force, not to be liable to be tried again for the same offence, nor on the same facts for any other offence for which a different charge from the one made against him might have been made under section 36 or for which he might have been convicted under section 237. Number 2. A person acquitted or convicted for any offence may be afterwards tried for any distinct offence for which a separate charge might have been made against him on the former trial under section 235 subsection 1. Number 3. A person convicted of any offence constituted by any act accusing consequences which together with such act constituted a different offence from that of which he was convicted may be afterwards tried for such last mentioned offence if the consequences had not happened or were not happened or were not known to the court to have happened at the time when he was convicted. Number 4. A person acquitted or convicted of any offence constituted by any act may, notwithstanding such acquittal or conviction, be subsequently charged with and tried for any other offence constituted by the same acts which he may have committed if the court by which he was first tried was not competent to try the offence with which he is subsequently charged. Number 5. Nothing in this section shall affect the provisions of section 26 of the General Classes Act 1897 or section 188 of this code. Explanation: the dismissal of a complaint, the stopping of proceedings under section 249 or the discharge of accused or is not acquittal for the purposes of this section. Of appeal, reference and revisions of appeals. Section 404. Unless otherwise provided, no appeal shall lie from any judgment of order of a criminal court except as provided for by this code or by any other law for the time being in force. Section 405. Appeal from order rejecting application for restoration of attached property. Any person whose application under section 89 for the delivery of property or the proceeds of the sale thereof has been rejected by any court may appeal to the court to which appeals ordinarily lie from the sentences of the former court. 406. Appeal from order requiring security for keeping the peace are for good behavior. Any person who has been ordered by a magistrate under section 118 to give security for keeping the peace or for good behavior may appeal against such order to the court of session, provided that nothing in this section shall apply to persons the proceedings against whom are laid before a session judge in accordance with the provisions of subsection 2 or subsection 3a or section 123. Section 406A. Appeal from order refusing to accept or rejecting a surety. Any person aggrieved by an order refusing to accept or rejecting a surety under section 122 may appeal against such order to the court of session, section 407, section 408. Appeal from sentence of assistant session judge or judicial magistrate. Any person convicted or a trial held by an assistant session judge or any judicial magistrate or any person sentenced under section 349 may appeal to the court of session, provided as follows. REP by Act 12 of 1923 section 23 B. When in any case an assistant session judge uh, passes any sentence of imprisonment for a term exceeding 4 years, the appeal of all or any of the accused convicted at such trials shall lie to the High Court. C. When any person is convicted by magistrate, special magistrate of an offence under section 124A of the Pakistan Penal Code, the appeal shall lie to the High Court. Section 409. Appeal to Court of Session how heard. Subject to the provisions of this section, an appeal to the Court of Session or Session Judge shall be heard by the Sessions Judge or by an Additional Sessions Judge or an Assistant Session Judge, provided that an Additional Session Judge shall hear only such appeals as the provincial government may by journal or special order direct or as the Sessions Judge of the division may make over to him, provided further that no such appeal shall be heard by an assistant session judge unless the appeal is of a person convicted on a trial held by a magistrate of the second class of third class. Section 410. Appeal from sentence of Court of Session. Any person convicted on a trial held by a sessions judge or an additional session judge may appeal to the High Court. Section 411 omitted by AO 1949 SCH. Section 411A. Appeal from sentence of High Court. Except in cases in which an appeal lies to the Supreme Court under Article 185 of the Constitution, any person convicted on a trial held by a High Court in the exercise of its original criminal jurisdiction may, notwithstanding anything contained in Section 418 or Section 423 subsection 2 or in the letters patent of any High Court, appeal to the High Court. A. Against the convict on any ground of appeal which involves a matter of law only. B. With the leave of the appellate court or upon the certificate of the judge who tried the case that it is a fit case for appeal against the conviction on any ground of appeal which involves a matter of fact only, or a matter of mixed law and fact, or any other ground which appears to the appellate court to be a sufficient ground of appeal, and C. With the leave of the appellate court against the sentence passed, unless the sentence is one fixed by law. Number 2. Notwithstanding anything contained in Section 417, the provincial government may direct the public prosecutor to present an appeal to the High Court from any order of acquittal passed by the High Court in the exercise of its original criminal jurisdiction, and such appeal may, with notwithstanding anything contained in Section 418 or Section 423, subsection 2, or in the letters patent of any High Court, but subject to the restrictions imposed by Clause B and Clause C of subsection A, subsection 1 of this section, on an appeal against a conviction lie on, on a matter of fact as well as a matter of law. Number 3. Notwithstanding anything else where contained in any act or regulation, an appeal under this section shall be heard by a division court of the High Court, composed of not less than 2 judges, being judges other than the judge or judges by whom the original trial was held, and if the constitution of such a division court is impracticable, the High Court shall report the circumstances to the provincial government, which shall take action with a view to the transfer of the appeal under Section 527 to another High Court. Number 4. Subject to such rules as may from time to time be made by the Supreme Court in this behalf, and to such conditions as the High Court may establish require an appeal shall lie to the Supreme Court for any order may on appeal under subsection 1 by a divisional court of the High Court, in respect of which order the High Court declares that the matter is a fit one for such appeal. Section 412. No appeal in certain cases which, when accused pleads guilty, notwithstanding anything herein before contained, where an accused person has pleaded guilty and has been convicted by a court, High Court, a court of session, or magistrate of the first class or class on such plea, there shall be no appeal except as to the extent of legality of the sentence. Section 413. No appeal in PT cases. Nothing, notwithstanding anything herein before contained, there shall be no appeal by a convicted person in cases in which a High Court passes sentence of imprisonment not exceeding 6 months only, or a fine not exceeding 200 rupees only, or in which a court of session passes a sentence of imprisonment not exceeding 1 month only, or in which a court of session or magistrate of the first class passes a sentence of fine not exceeding 50 rupees only. Explanation. There is no appeal from a sentence of imprisonment passed by such court or magistrate in default of payment of fine, when no substantive sentence or imprisonment has also been passed. Section 414. No appeal from certain summary convictions. Notwithstanding any here anything herein before contained, there shall be no appeal by a convicted person in any case tried summary in which a magistrate empowered to act under section 260 passes a sentence of fine not exceeding 2000 rupees only. Section 414A. No appeal from certain summary convictions under the law relating to price control. ये इंशाल्लाह हम कल पढ़ेंगे। कल तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आप तमाम दोस्तों से गुजारिश करता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। तब तक के लिए मुझे इजाज़त दें। अल्लाह हाफिज़।